social media disasters, which I'm sure everyone's really interested in hearing more about, especially because it's gained such attention in recent months in the media. This session will actually be moderated by Newson Ainsworth, who's a lecturer in law at the College of Law and Justice at Victoria University, and we'll have three presenters on the panel: Bill Doogue, the principal from Doogue O'Brien; John Fogarty, senior associate at Corrs Chambers Westgarth; and Leigh Howard, who's a lawyer at Clayton. I'll just introduce Newson Ainsworth. He's a passionate and regular presenter on incorporating technology and social media into legal and professional advice industries. His current seminar series with the LIV is entitled The Mobile Lawyer, Getting the Most from Technology. Newson practiced as a solicitor in a Melbourne commercial law firm prior to his appointment to Victoria University as a lecturer in law. He's a member of the Law Institute of Victoria's Alternative Dispute Resolution and Practice Support Section Executive Committee, and is a nationally accredited mediator and family mediator. I now invite Newson to mediate the panel. Thank you.
Thank you, Michelle, for that introduction. Welcome everyone to this great event. Just some housekeeping to start with. This structure of the session will be loosely as follows. I'll make some opening remarks about social media. I'll then introduce each panel member in turn and ask them to speak about social media in their specialty area, followed by them as a panel tackling your amazing, insightful, well thought out, or even simple questions. So I'm very excited to be part of a great session on social media. The session is advertised Social Media Disasters, and I'll quote, crime and social media commercial entities are responsible for disparaging third-party comments, sacked employees. This panel will reveal the dangers of social media. Social media in law is rapidly developing and creating new and interesting benefits, ethical issues, and causes for concern, and for today's purposes, disasters. We would really like you to participate and engage in this session. I know it's still early in the day and some of you are still settling in, so I'll try to start with just a few questions just to gauge where you guys are standing. I mean, just by a show of hands, who here is familiar with social media? That's very intimidating. Thank you. And who uses, maybe just by a show of hands, who uses LinkedIn? Facebook, and the least popular of them all, Twitter. Perfect. So now that we've gone through that, I'll ask you all to reach forward and grab a pen and those pads that are kindly provided by the Sofitel to write down your questions and your thoughts, because I know sometimes at the end of panel sessions, the questions are sometimes slow to come by. So if while we're going, you guys could write down those wonderful questions that are popping up and really engage the panel, that'd be great. Just a few words I'll go through. When preparing for today, I was initially surprised to see the breadth of opportunities, benefits, and issues social media raises in law. Every aspect of law is being confronted with the unknown that has, is, and will come from the implementation of social media. Social media is changing the face of law and legal practice faster and in more ways than any of us in this room realize or can even imagine. This is not meant to be a bold and extreme statement. It is simply the writing on the wall. The human conversation is shifting, and social media is playing the central role in the shift. With the expedited uptake of social media and mobile technology, we are changing the way we interact and communicate. The broader effect of this is outside the scope of this session, but in the legal context, as I mentioned before, the effects are and will be huge, and here in Australia, I'll boldly predict and state that we are going to be hit by a tsunami of social media-related issues. At the opening of the law term dinner this year in New South Wales, the Chief Justice Bathurst made the following predictions in his address. This was only a few weeks ago. Judicial interaction with the public and press will continue to increase in line with changing community expectations about access to information. We may even follow in the United Kingdom Supreme Court's footsteps by uploading videos of judgments being delivered to YouTube and tweeting outcomes. That was his prediction. The Chief Justice's predictions are already a reality here in Victoria. The Victorian Supreme Court and, on the federal level, the Family Court are both on Twitter. The Victorian Supreme Court is well ahead when it comes to Twitter and social media in general. It tweets criminal sentences, significant civil judgments, And announcements. The Corrs first tweeted 18 March 2011 and now has over 1,400 followers and just shy of making its 300th tweet. The family court first tweeted towards the end of 2012, not as prominent in that space, but it has 380 followers and about 60 tweets. The LIV Ethics Committee hotline receives about 3,000 calls a year. Of those calls, only a handful are social media related. I can only think of two reasons why this is so. One, social media and with that technology are conservatively utilized by the legal profession, and two, lawyers are not aware of the reality of the legal implementation. Everyone knows the word I'm trying to say, right? Okay, we'll move on. That social media can cost. A 2012 report by the International Bar Association stated that every act in the legal arena has felt some effect of online social networking on the daily practice. At present, the corresponding standard of appropriate or acceptable behavior in such areas is somewhat contentious and unsettled. Results of the survey which fed that report were that 80% of survey respondents stated that currently the legal profession in their area are not adequate. The legal professional codes and guidelines are not adequate for applications to social media and need to be updated. The Law Society of England and Wales stated when engaging in social media, a fundamental consideration is the blurring of the boundaries between personal and professional use, and the importance of recognizing that the same ethical standards and obligations apply to professional conduct in an online environment. A testament to the LIV, a testament to the innovation and currency, is the fact that they have published guidelines on ethical use of social media, which were adopted by the Council at the end of 2012. Briefly, they address many areas including confidentiality, inadvertent retainer, duty to the administration of justice, breach of no contact rule, defamation, advising clients on social media generally, and their risks, employees' use of social media and risk to reputation. The guidelines are included in your handout, so please feel free to go through them. My intention in that not so brief, turns out, introduction was not to make you all leave this room and swear I'll never engage in social media. The risks are just far too much. On the contrary, the fact is that social media is here to stay. There are huge benefits from the user. In my opinion, the biggest social media disaster today would be the failure to use and reap its benefits.